Isokuhle Ntuli was arrested, charged, and sentenced on Patfontein Case 50 of June 2016 for 4 times attempted murder charges. He appealed and was granted bail. Whilst on bail, he was arrested and charged on 4 murder cases. As per Nongoma Case 30 of April 2016, 391 2016, also Nongoma 88 Nongoma, as well as 127 Nongoma, all of them in 2018.
Yeah.
And possession of unlicensed firearm as per Nongoma Case 285 of 2017 and Nongoma Case 147 of 2018 June that he is alleged to have committed while on appeal.
So this accused is actually charged, convicted, and sentenced. Then he appeals. He's granted bail while he's awaiting his appeal. And in that period, manages to commit 4 more murders.
That is correct.
Okay. Now, it's a fairly, well, not too long, but it's about 6 pages. So if you could just quickly flip through that document and tell the commissioners what that document is. Then we will work through the detail of the document.
It's an NPA internal correspondence from the Director of Public Prosecution in KwaZulu-Natal. It's addressed to the Advocate Batohi and is from the Minister of Police. If I had to check the signature part of it, which is at page 209, it was signed by Minister of Police, Mr. Klele, on the, I think the date is 24th of the 5th month, 2019. It's just written, it's not quite clear exactly the date, but it's a letter from the Police Ministry to the National Director of Public Prosecution.
Yes. And this letter is shared with you by Advocate Harrison.
That is correct.
Let us consider the contents of the letter. And we do so. We start at page 203. And I take it that you would be familiar with the facts set out in this letter, in this document, because on my reading, this letter refers to politically related killings in your area of jurisdiction. Is that a fair assumption?
Yeah, that's correct.
Let's look at the challenges at page 203. The letter highlights challenges identified, and at item 3. At item 3.1, he references section 204, witnesses killed while in the witness protection program, and he gives an example below that. You confirm that?
That's correct.
At item 3.3, same page, the heading is section 204, witnesses turned against the state. And at subparagraph 3.3.1, witnesses who abandoned witness protection program. Can you shed light as to what he's talking about, the minister is talking about there?
Commissioners, I must indicate that, as I've indicated before, that the IMC will be receiving briefing from the team. So part of the briefing to the IMC will be to indicate challenges that the team will experience. And some of these challenges are the ones that are listed in this letter. A typical example of a witness that will turn against the state will be a person that will have a first-hand information. It could be the person was part of the commission of a crime and turn witness, and the person who was involved, directly involved. But because of the delays and challenges, maybe that person is approached by the main suspect. In the hierarchy of this organized killing, you'll find a person who's controlling the purse, a person who's got the money, will coordinate this killing will not do the job himself or herself, but will pay someone to find the hitman. So even if we arrest a hitman, the person who hired the hitman, who have received money, is the one that maybe turns out to be our witness. But if that person is compensated somehow, is persuaded somehow not to assist the police, and that's a person who then withdraws his services. But there are reasons of withdrawal, obviously differ. At times it could be through intimidation that leads into that person turning against the state.
And on the same document, the same page 204 on our, no same, overleaf 204, item 4. There is a table there that flows over to page 205, and that table is headed questionable withdrawal decisions by the NPA. And commissioners, we apologize for the poor quality, but to assist, the first column reads station and case number. The second column reads decision, and the third column reads prosecutor. So this table sets out the details of specific cases and the decisions.
The second column?
Decision. So it's a summary of the decision or the basis on which they put forward for the withdrawal of the case. And the last column indicates who the prosecutor was in that matter. So it's called prosecutor there. It's a list of 11. And just to give the commissioners perhaps a flavor of the issues that are raised, which lead the drafter of this document to call them questionable withdrawal decisions by the NPA. We will not highlight the names of the prosecutors who were involved. We'll just concentrate on some of the reasons advanced for the withdrawal. So I will ask you to read the reason in respect of case 1.
On case 1, the reason suspect placed on the roll and later withdrawn.
And that was a case, that was a murder case according to this document, column 1.
That is correct.
The next 2 cases were for intimidation. They too were withdrawn, and please read into the record the reasons advanced for the withdrawal there.
The reasons advanced by the prosecutor here, I quote, "You will feel the heat does not amount to intimidation, which resulted in all 3 cases being declined to prosecute."
Then I will turn over to page 205. Again, I pick a different one. Item 9, that was a case of unlawful possession of a firearm. Please read that reason, the reason advanced for withdrawing that one.
The owner of the security company does not cooperate to rectify the queries regarding the investigation.
And lastly then, item number 11. This is in respect of possession of unlicensed firearm and ammunition.
Unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which link the suspect to the case.
Yesterday you testified to the novelty of the task team approach in investigation.
Sorry, before you do that,
Yes.
just so that I make sure I understand, the reasons where it says decision in that column,
Yes.
are these the notes of the prosecutor, or this is Minister Cele saying it's unreasonable to demand additional evidence? I'm looking at your example 11, right, where it says unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which links the suspect to the case.
Yes.
Is this the prosecutor saying that, or it is Minister Cele raising his concern about the decision not to prosecute?
So my understanding of the table we've gone through, as if we consider it in the context of the heading, questionable withdrawal decisions by the NPA. So the decision to withdraw has been taken by the NPA. And the issue is that the reasons advanced for the withdrawal are questionable. So that column that is headed decision seeks, as I understand it, to highlight the reason that was advanced at the time of withdrawal. So I did not read this table to include any personal input by or opinion by Minister Gele.
Okay.
He was just reflecting what is already on
What is
record
recorded. Okay.
regarding these decisions by the NPA.
Thank you.
Thank you.
Thanks. This is still confusing though.
Okay.
Because I cannot see the prosecutor saying that they unreasonably demanded additional evidence. So probably it's the minister here expressing his own view, and maybe what happened is that it was the prosecutor who was insisting on additional evidence. And so the minister is expressing his view that that was unreasonable because there was sufficient evidence. So this one sounds to be an exception to what you are saying, which is what's in that column is the decision as was recorded. But,
I would perhaps ask that we park the issue for the moment. As we work through the document, we will realize that the minister technically is quoting the information that became available to him regarding all these issues. Because sometimes it gets so specific that is information he simply could not have. So clearly the source of the information, he is reflecting the situation on the ground. He concludes at page 209 with the findings and recommendations. So I understood that document and the table set out therein not to be expressing his view.
Perhaps to save time, let's
Yes.
just say my co-commissioner, Commissioner Baloyi, did raise this, and let's just leave it at that for now.
Indeed, I hope by the time we get to the conclusion of this document,
Yes.
perhaps then we'll have a better understanding. Maybe just a question of how it's expressed.
Yes.
But it would seem to suggest that the last column gives you the name of the prosecutor who was involved. The second column gives you the reason why it was withdrawn. This particular one seems to have a comment that it was unreasonable. The case was ready to go to trial, but there seemed to have been further demand for evidence. Now, it may potentially mean that the prosecutor himself was refusing to take the matter to trial and demanding more evidence, when in essence, practically, the matter was
Yes,
ready.
and then someone else says that was unreasonable. Because this is the minister's document, it's on that basis that we think
That it might be him.
is the minister expressing that opinion. But as I
We
said,
can flag it.
in the interest of
We'll
time,
we'll find out exactly where that comes from.
yes, let's move on.
The next table, still on page 205, deals with what the author calls the questionable decisions by the NPA. And the headings there are, once again, case number and the charge, and the second column should read decisions. Here, there are two cases, two murder cases. And if you could just quickly highlight what under the column decision advanced in respect of each general.
The first case is Ntuzuma case 242 of 10/2012. It's a murder case. The NPA guidance to take the case for formal inquest instead of trial, despite strong evidence of premeditated murder. The second one is Plesisler case 2335 of 2018, murder. Unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which links the suspect to the case.
And just for completeness, then at page 206, it's a similar table, but this time it speaks to speedy trials delayed. Do you see that? And
Yes.
it follows the same format. It gives you the name of the accused, the case number, and then the decision advanced. Would I be correct to suggest that all these are matters that the task team at the time regarding head to the fact that this is generated in 2019, that the task team was concerned about, which is delay in prosecuting matters that have been investigated? Would that be a correct understanding of this document?
That is correct.
Then if we go at 207, under item 8, accused granted bail whilst on bail. Now that goes over till 208. Starts at 207 into 208. We don't have to read them. You could choose an example to highlight what the concern is here about accused being granted bail whilst on bail. There are 6 instances, I think, that are quoted in the letter. We'll deal with any one of your choice.
Yes. 8.1. Sifiso Hadebe, a well-known hitman, was arrested on IB's case 91 of April 2017. Murder of Councillor Tobela was granted 10,000 rand bail. While out on bail, he committed another offences as per AB's case 869/2018, the discharging of firearm, and was granted 1,000 rand bail. Mzimkulu case 5 of 10/2018, possession of unlicensed firearm, granted 1,000 rand bail. And Mzimkulu case 112 of 10/2018, possession of unlicensed firearm and ammunition, granted 2,000 rand bail. Bail was opposed on all cases, but it was unsuccessful.
So the situation is you have an accused, they are charged, they are arrested, they are granted bail, they are released. And then another case arises, they are arrested, they apply for bail, and then they get a second bail, and so it goes. Sounds like it's 4 bails on top of the first. Is that correct?
That's correct.
Do you agree with what's written at page 207, that that is a concern for you as the head of the political task team, as a member, and as a police officer? Is that a concern? And if so, why?
It is a concern indeed. As I said earlier, that this will have been an extract of the briefing that was given to the IMCs about the challenges that we're experiencing with regard to the prosecution of these cases. That when a person has been accused of a serious murder case, arrested, granted 10,000 rand bail, and you commit other serious crimes thereafter of possession of firearms, but still giving bails, it simply means that the court is not taking serious the risk that this individual has in society. That if he keeps granted bail because of murder and is arrested with a firearm again, and is granted another bail, and again arrested because of the firearm charge, and granted bail again, it simply means that he is allowed to go out there and carry a firearm and do whatever he wants to do with the firearm. The court does not see the need of stopping this person from doing it. And this has a serious consequences towards the witnesses and many other people that are involved on cases that this person is arrested for.
And perhaps for the sake of completeness, let's look at case at page 208, which is a slightly different case, but along, in the same vein, under item 8.6, if you could read that.
Fisokuhle Ntuli was arrested, charged, and sentenced on Patfontein case 50 of June 2016 for 4 times attempted murder charges. He appealed and was granted bail. Whilst on bail, he was arrested and charged on 4 murder cases. as per Nongoma case 30 of April 2016, 391 2016, also Nongoma 88 Nongoma, as well as 127 Nongoma, all of them in 2018.
Yeah.
And possession of unlicensed firearm as per Nongoma case 285 of 2017, and Nongoma case 147 of 2018 June, that he is alleged to have committed while on appeal.
So this accused is actually charged, convicted, and sentenced. Then he appeals. He's granted bail while he's awaiting his appeal. And in that period, manages to commit 4 more murders.
That is correct.
Okay. Now,
Manages to be charged with a commission of.
that's more precise, legally correct, yes, manages to be charged. Then, I think what we have just worked through, which was what Minister Gele at the time communicated to Advocate Bagtoy, culminates in certain findings and then followed by recommendations, and that's set out at page 209. I think it is important to appreciate the findings made in 2019 because that gives a sense of the situation as it prevailed in 2019, appreciated even by the minister. So if you could read the findings under item 9 at 209. 9.
The findings reads as follows. The political related cases, especially murder, are organized in nature with different role players carefully identified, that is hitmen, spotters, coordinators, and individuals at the top who are ordering the hits. Bullet 2, most cases are dependent on Section 204 witnesses that were part of the syndicate, especially when the investigation has to be directed against individuals on top, open bracket, politicians and entrepreneurs, close bracket. Bullet 3, the involvement of politicians and business people possess a threat of attempts to bribe the criminal justice system personnel. If it fails, then attempts to turn Section 204 against the state. If that fails, then they kill the state witness, which results in the case being withdrawn. Paragraph 4, bullet 4, the lack of dedicated prosecutors to guide and prosecute on allocated cases. Bullet 6, bullet 5, the trial-ready cases being postponed for a longer period due to unavailability of dedicated magistrates. The last bullet, the repetitive granting of bail to accused who are already on bail.
Yes. So those were the findings that Minister Gele drew at the time. Did they accord with your experience and knowledge with the situation as was prevailing in KZN at the time?
That is correct, Commissioners.
And he turns then lastly at item 10 by making recommendations to Advocate Batoyi. If you could just quickly read those into the record.
Recommendations, 4 of them reads as follows. Bullet 1, a dedicated courtroom for the processing of the politically related cases. Bullet 2, dedicated preferable prosecutors and magistrates to deal with these cases. Bullet 3, appointment of a permanent KZN director of public prosecution. Bullet 4, urgent appointment or utilization of police officials to fulfill the function of the security officers in the Witness Protection Program as prescribed in the Witness Protection Act 112 of 1998, Section 3, 5A, Roman figure 3, and Section 6B.
And he concludes the letter. Now we go back to...
Ms. Silo, before you leave this letter, You asked the general whether what is under the findings in those bullets
Yes.
accords with his knowledge and experience at the time.
Indeed.
And he's answered in the affirmative. I want to ask a question, but I don't want to anticipate where you're going to go. I would have done a follow-up of, as at the date of the letter which disbands or that seeks to disestablish the PKTT, which is what, in December, these factors in bullets 1, 2, 3, under findings, what the position was. I want to ask that, but if you are going to be dealing with it in your own way, I don't want to interfere with it. So
Well,
you stop me.
There would have, we're prepared to deal with it in another way,
Okay.
but it doesn't change the course of anything.
Okay.
It can be dealt with now. Now that the commissioner has put it out there, perhaps the
You
general
can
respond
deal
to
with it. Okay.
No, the general can respond to it immediately.
General, you've had in 2019, you say that you were aware of those factors in bullet 1, 2, 3, and these are the politically related cases, especially murder, are organized in that way described there. Most of the cases are dependent on Section 204 witnesses, and then bullet 3, the involvement of politicians and business people. Is as at 2024, when Minister Mkunu sends the letter or the instruction to disband the political killing stars team, what in your impression and experience is the position? Is it still the same? Is it any different?
It remains the same, Commissioner, that there is a lot of interference with these investigations in different forms, as is listed there, in order to try and close these cases by business people and politicians. And by and large, because they're political cases, the people on the higher level of the syndicates that are involved are the ones that are behind the closures of dockets. So the influence the docket still remains the case to date.
Family, we are back in MADLANGA Commission of Inquiry, whereby we see Mr. MKHWANAZI, the hero of our country, who has taken the bull by its horns. So he is now being tested, his evidence, in the Commissioner of Inquiry, which is the MADLANGA Commission of Inquiry. So, second day, he has done something. It was never like the first day. Now he was coming with receipts, dropping names. Parliament, he touched on Parliament. He touched on Metropolis. He touched on Kakiso. He touched on Begicele. He touched on Vusiket Mashala. He touched a lot today. And what surprised me when he was talking about all these things, it was the SENZO MEYIWA case, whereby he named one of the accused in the SENZO MEYIWA case, accused number 5. We know accused number 5 that he is serving his sentence for whatever long term that he is serving, but though we still don't believe that he was part of the SENZO MEYIWA deleting of his life. We don't believe in that because the evidence that we see there, it doesn't give us kind of confidence that he was part of that. He might have done other things that he is being sentenced of, but for this one, when we look at the evidence that is being produced in the court of law, it's kind of water and oil. It doesn't mix up. So the second day, when Lieutenant General MKHWANAZI was dropping names, we don't know what is going to happen tomorrow morning because he seemed to gaining steam each and every day, because I don't know how Senzo, the minister, will defend all this, because he even named some from the DA, some business people. He was just on the start on the business people who are part of the dark world, the underworld, that is busy making a lot of mess in our country. But my opinion or my thinking, because he said there's so many police, and he didn't name and even prosecutors. But what bugged my mind, they were able to name other people, but when it comes to the prosecutors, it was kind of too tender on that. They didn't want to name the prosecutors. But because we want, when the names are being dropped, let everybody know who does what happens, not to protect. Because when MKHWANAZI came up on the press conference, he said a lot, a mouthful. But now it's like he is being there's a pushback. Like, okay, even if the one who is guiding MKHWANAZI she was kind of even if you don't name names, but at some point some are allowed to be displayed in like in Nduli, the member of parliament, and all those. I don't understand why how it happens. It works like that because if they are naming names, everybody must know because the country, those people are destroying the country. There are lives that are being lost in the country because of this kind of shenanigans that are going on. I wish the names, nobody restrict anybody from dropping names so that we can know the corrupt ones. And I'm still waiting to see what is going to happen with the Metro Police. We remember accused number one. It's where he was interrogated in Fosoras, in that area where they went to go to local. As some of the police are named there, I wonder where is Brigadier Kininda? Why is he left? I think his name is coming up soon. Brigadier Kininda's name will come up soon. Definitely, I can't miss my words there. Definitely something will come up. Because those are the people that Brigadier Kininda were used to torture accused number. Now the puzzle is starting to connect. Let's wait and see, allegedly. Family, what do you think about this? We heard his name being mentioned, Sifiso Nduli. He's been a bad guy, but you can be bad, but you can be tied to a case whereby you were not even part of it. But being a bad guy is not every case you are involved in it. It's not a way of defending him. He might have done all this kind of bad things, but at some point, when you look at the evidence and think about everything that we've been following in this Senzo Meyiwa case, we find that there is water and oil that doesn't mix. Anyway, what do you think, family? Drop your comments. Don't forget to like and share. Soon, on the 22nd, we are back in the Senzo Meyiwa case. Bravo, bravo, bravo.